Now, Waller County, what has Waller County filed? Other than what we instructed the attorneys that we would agree to the voiding, we have not agreed on any other issue. Okay? So Waller County has filed a judgment notwithstanding the verdict. That means you're asking the judge to disregard the jury and take it away from the jury. Okay? It's not something that happens very often. I probably, unless you've got a runaway jury or you have a jury misconduct, of which I've heard of none in this case, it's probably not something that's likely to be granted. However, there are legal arguments that are also being made. One is that Cal and the city don't have certain legal standing because some of the issues are moot because we've agreed that the host agreement and the landfill ordinance can be voided, and therefore you don't need injunctions anymore. You don't need to get an injunction ordering us not to comply. Not to mention the fact that you have 3 commissioners right now in this court. We've never broken the law. Why? What? 4. I'm sorry. Well, 3 new. I said 3 new commissioners.
Well, no, you're a judge.
And that's right. I'm a judge. And then, of course, you have Commissioner Barnett. Which, by the way, Commissioner Barnett, when this host agreement, and it should be said, when this host agreement and landfill ordinance were passed, Commissioner Barnett voted against it. Okay. In addition to Commissioner Amsler. So, the injunctive relief is improper again because. Again, these are legal arguments, keep in mind. The relief was vague. The relief sought was outside the scope of the pleading, and we have new commissioner court members. We have not been named in the suit. We have not been found guilty of any wrongdoing. Now you may say, well, what difference does it make? Well, as a judge, and I'm sure as a commissioner, I want to be able to do my job, and if I do something wrong, we'll file a complaint with the DA if it's a PIA violation or what have you. I don't think it's fair for me to just go to a judge and say, Judge Duhon should be held in contempt because there's a standing order. I've not violated any laws to date. So those are some of the legal arguments. Also, injunctive relief is improper under the Public Information Act because injunction is not an available remedy under PIA. So under Public Information Act, the statute provides that if you don't get the information you're requesting on a PIA request, you can either file suit and ask the court to order that official to comply, or you can go to the DA and you can file a complaint. Well, in this case, this is a civil suit. So there's a legal argument that we're making that PIA doesn't apply. And again, keep in mind, this is a legal argument the county is making. Additional responses that we've got in our motion to the entry of judgment. That the county believes that 364.012 does give a county the authority in the ETJ, that the meeting notices were proper, and that no attorney's fees for PIA, Open Meetings Act, or Declaratory Judgment Act if the conduct of Commissioner's Court is determined was reasonable. Okay. Now, let's go back to the declaratory judgment because that's something I want to talk about for a second. When it comes to you know what, let me finish the extremes and then we can talk about it. So, and then there's also, Waller County's also got issues with how those fees were calculated and whether or not those fees were properly segregated. So, settlement. Settlement would include an agreement with the above referenced possibilities. The general purpose is to hopefully that you meet, but somewhere between the 2 extremes, okay? So on one hand, we have Cal, City of Hempstead getting all the relief that they request, all the attorney's fees that they request, injunction, declaratory judgment, all the findings of fact. On the other extreme, you have the county with a judgment NOV, and the judge says, you know what, I'm going to disregard the jury and I'm just going to dismiss this lawsuit. Those are the 2 extremes, okay? And then you have all these possibilities in between as far as a possible settlement. So when it comes to settlement, I can't tell you right now. The reason I cannot tell you where we are is because we have not gotten signed settlement terms from all the parties. In the last month, 40 days, we have been earnestly pursuing settlement negotiations with all the parties. And it was to do a global settlement, where there would be a settlement where attorney's fees would be capped at a given amount, We would agree on whether there would be any findings of fact or not. The declaratory judgment, those were all the issues that were on the table. So we've been doing this back and forth, and those discussions have been extremely productive and they've been very positive. Now, in the last few weeks, I will say it seems like they have slowed down considerably and they've kind of stalled out. I was hopeful that we would have had those settlement terms 2 weeks ago. We have received the settlement terms sheet from Cal. We just this past week got the settlement term sheet from the city. We have not gotten a settlement term sheet from Pintail. My understanding is there was some back and forth between Pintail and Cal on some of the wording, on some of the settlement documents, and that has gone on and on now for days, since last week. I was hoping that would get worked out and we would have settlement term sheets today. I got a message from our attorneys, and the message was that they had gotten a message from Brent Ryan. He's the attorney for Pintail, and he was letting them know that he is at this point unable to get a hold of Ernest Kaufman, the president of Pintail, because he's out of the country and doesn't have any phone service, and will be that way for the next week. Right. So I'm not sure why these discussions couldn't have happened 2 weeks prior. So I can tell you, we were hoping, we originally 2 weeks ago were hopeful that by now we would have had settlement terms. We would have made those public to everyone. We would have given everyone an opportunity to take those into consideration, to digest them, to give feedback to their representatives, and then we were going to vote at tomorrow's meeting as to approve or disapprove the settlement. Keeping in mind, we have a deadline, or there's a hearing date that's set on February 20th. Now, can that date be changed? Well, I'm sure it can if all the parties agree. Will they? I'd be surprised. I would really be surprised at this point. So, Waller County, the extremes, Cal and Hempstead getting everything they're asking for, or Waller County and Pintail having judgment notwithstanding the verdict. There would more than likely be an appeal if we don't have a settlement. No matter how it comes out, there's probably going to be an appeal. So it's not going to be the end. It's going to be additional appeals, Court of Appeals, Texas Supreme Court. It's your guess is as good as mine as to who is going to end up footing the bill for those appeals. If the judge doesn't void the host agreement, or if it's not voided as a result of a settlement, then obviously there could be a question as to whether we probably are going to have to pay those attorney's fees ourselves. All the way up to Supreme Court and back, who knows. So again, that's why you pursue settlement, obviously, because it provides an opportunity to say this is what we're going to pay. There won't be any more appeals. It is stopping the bleeding. Stopping the bleeding. Under an agreed settlement, the parties do not get everything that they are requesting, and they negotiate terms that are agreeable to them in order to resolve the lawsuit and move forward. So, all I can say is if we're pursuing a settlement, we're obviously seeking an amount. It would be a settlement for an amount far less than the $800,000 that's being sought in attorney's fees. Okay? That would be a given. The other issue that I think is a big issue that I told you earlier is what I worry about the most is this declaratory judgment. And the reason I worry about the declaratory judgment is because if we have a judge in Waller County who issues a declaratory judgment that says the county has no authority to regulate landfills inside of a city's ETJ, that becomes the law of the land in Waller County. Now, is there any other law out there on this issue? I have talked to a lot of different folks. I have talked to legal counsel. I have been told, and my understanding is, this is what we call an unsettled question of law. There is some case law out of Chambers County where a judge ruled that the county could not regulate landfills inside of a city's ETJ. That got taken up on appeal. It was reversed and remanded on other grounds. So we really don't know whether or not that is any legal authority or not. There is an Attorney General opinion, again, kind of touching on this issue, that says a county cannot regulate waste disposal services within a city's ETJ. but that's not a landfill. It's not on point. It had to do with contracts for waste disposal, like, trash trucks to come through. So again, now the attorneys, they love this kind of thing because they know regardless of how the judge rules, we'll take it up on appeal and we get to go establish new law. Question is, who gets to pay for all of that? So what happens if that judge does a declaratory judgment and the judge voids the landfill ordinance? If the 2013 landfill ordinance is voided, we are now back at the 2011 ordinance, which admittingly, and this my personal opinion, I'll make that clear, I never liked the 2011 ordinance, the Monaville ordinance. Because at the time it was passed, I thought folks in Monaville were getting thrown under the bus because it was done so fast. And I didn't really feel like they had a fair opportunity to be heard and to voice their opinions. And I just didn't think that that was the right way to deal with this problem. But it is what it is, and that's what we have now. If the 2013 ordinance goes away, you have 2011. And again, that's drawing this 2-mile circle, around Monaville or any other previously permitted landfill. But if that declaratory judgment says, county, you don't have the right or the legal authority to regulate landfills inside of a city's ETJ, it is now going to be open season on Waller, Prairie View, Pine Island, Hempstead. We would have to agree, that would be probably an agreement between us and them that we won't come anywhere near them. But Pattison, Brookshire, and I guess even Katy, we cannot do anything inside of these city limits. It would be up to those cities to basically protect themselves. Now, you can't just go in and say no landfills allowed in Pattison or no landfills allowed in Pine Island. It's not that simple. You have to actually hire people that know how to determine where a good spot is, bad spot is. You have to have good science. Then you can go in and basically zone as to where landfills can or cannot be built. Debbie, how much money do y'all have to do this kind of project? Probably not enough, right?
Not enough, but we could start something.
Well, right now you have nothing on the books. Correct? You don't have an ordinance regulating landfills.
No.
Okay. And none of these cities do. So, and you look at 290, and that worries me. I'm worried about Prairie View because you're right off of 290. That's ideal for a landfill company. Pine Island, similarly situated. Waller, Pattison, Brookshire, right on I-10. So I think that you basically have open season. And granted, the 2011 ordinance isn't great, but it does give us something that's on the books. So that's why I worry about the declaratory judgment. That's why there's a settlement. That's one of the things I would definitely want to just be pulled off the table, so that we are not worried about that. We can still protect this county under 2011. Now let me say this. 2011 ordinance needs to be changed. I've been told, I've been at commissioners court meetings, we've talked to a lot of folks who are experts on this kind of stuff. They say that you can actually designate an area probably at 200 acres, and that meets legal requirements. So we don't need a 2-mile circle. But I still don't even know, we haven't even really had an honest conversation as to whether or not that's the appropriate place or not. We've never even done that. Here we are, 3-4 years later, we still haven't had that conversation in this county. Which 3 or 4 years later, we don't have a comprehensive waste management plan, which is what got us into this mess to begin with. This is something we were required by law to have. We are not required by law to have a landfill. We are required by law to have a comprehensive waste management plan. In fact, 2013, when they 2011, when they passed that ordinance, the Monaville ordinance, at the Road and Bridge Annex, I stood up and I spoke against it because I thought people were being thrown under the bus. And it wasn't a popular thing to do. And there was a lot of boos. And but I was promised that we would start working. This was just a stopgap, and that we would all start working on a comprehensive waste management plan right away. It never happened. And even within the next year, within this past year, I kind of saw where this trial was going. And again, I spoke at Commissioner's Court. I begged and pleaded to stop the bleeding, stop the attorney's fees, settle this lawsuit now. It's just going to get worse as it goes on. Okay, and that fell on deaf ears. But, so we have two extremes. So the question is, where are we going to end up in the middle? Do we settle this case? Do we not? What I want to do now, we're going to open it up to questions. Commissioner Beckendorff, well, I'm going to let Commissioner Beckendorff and Commissioner Barnett also have an opportunity to speak. I think it's important to keep all of this in mind. What we are doing, I've been practicing law 20 years. I've probably never been involved in a case that has the complexities that this case has. We've been in executive session since the first week in January, probably over 10 hours in executive session, going over the nuances as far as, how we're going to get this done, can we get this done, what our position is going to be, how these legal issues. Keep in mind, I've outlined all those findings of fact, all of those remedies that are being sought: injunction, declaratory judgment, attorney's fees award, findings of fact. All of those can be, any one of those can be appealed, and then the Court of Appeals can come back and rule one way or the other. You could go up and appeal on the whole case, and they might say, yes, the Public Information Act claims were improper. However, the jury verdict as to Open Meetings Act and the attorney's fees awarded thereon are going to be upheld. So again, in that case, you may go all the way up there and still lose. But now we're out how many hundreds of thousands of attorney's fees on top of what we're going to be ordered to pay at the end of the day. It's all question marks. It's all uncertainty. That's what settlement does. It allows us to put definite answers in place of those question marks. What is it going to cost the county? What is it going to cost the county going forward? Well, if we settle going forward, we may lose the host agreement, but as far as this litigation, we're not going to have any other damages. We're not going to have any more attorney's fees. There aren't going to be any more appeals. We don't have to worry about Pintail or some other company coming in and saying, wow, this is a great spot right here in Pine Island. We're going to buy that, and there's nothing the county can do about it.
You have to have a willing seller first.
That's true. You're absolutely
Nobody
right.
on Pine Island wants to dump, so they'll never sell.
You're right. Keep in mind, just keep in mind, you don't always know who you're selling to. Straw men get used all the time in this county. You think you're selling to somebody, and I have a feeling, I think the folks that own the Warren Ranch may tell you the same thing. They probably didn't know they were selling to a landfill when they entered into the option agreement. So that kind of brings you up to speed on where we are, what we've been doing. I would love to open this up to questions. I think what I'm going to do first, though, and let me say this, I didn't say this at the beginning, and this is a relatively small group, and I know a lot of the faces in here. I don't think I need to say this, but I'm going to anyway. I want everybody to keep the discussion civil. There is no need for personal attacks. We can agree to disagree. You can disagree with your neighbor, but I'm not going to be real tolerating of where somebody's going to get personally attacked. You can challenge somebody, you can ask them a question, you can say why do you feel that way? But if it gets personal, that's not what this is about. This is about providing information. And as far as I'm concerned, when it comes to a matter of public interest, ignorance cannot be tolerated. I want you to have all the information that you need so that you can make an educated opinion. So you can go to your commissioners and you can tell them what you think. Because at the end of the day, we work for you. It's not the other way around. All the authority we have is vested in us by virtue of you. So we need to know how you feel. We are trying to do everything we can to do what's right in the best interest of this county. Okay, and we're all working very hard to that end. So, with that, I'm now going to allow Commissioner Beckendorff and Commissioner Barnett to make comments, statements, and then we'll take it from there.
You first. Good evening, everyone. Thank you all for being here. Let me say, first off, prior to all this stuff, except for the litigation, I was not commissioned. Okay, so let's put that out there. Also, this is your host agreement. Okay, this is 58 pages of wording, documentation, that's telling you what all is entailed in this host agreement. Now, for those of you that have been all the CAL members and City of Hempstead, I'm pretty sure you know this thing inside out, okay? Because some of you told me about this, so I know you know it inside out. Now, for the average citizen, okay, in our county, I can assure you that they do not. My concern for you, and particularly you that live in Precinct 3, because I represent you, is that you don't know what's in here, okay? The judge showed you earlier a dollar amount, and last night I think that dollar amount as far as litigation was close to $1 million overall when it was said and done last night. We were looking at close to $1 million. Now, when I came in as county commissioner, 2013, I was asked to vote this up or vote this down. I had not read this, okay? Not knowing what it all entailed from front to end, not even understanding what was in this. I voted against it. I voted against this, and I voted against the 2013 ordinance. But I will be truthful with you since then. I have read this just like many of you all have. I have gone to sleep with these words in the front of my mind, in the back of my mind, waking up with them, okay, in my thoughts. Instead of telling my wife good morning, hello, host agreement. Okay? That's how deep I have gone into this. Okay? Now, before we do any settling, before we do anything in reference to this, I feel that you, the citizen, need to know what's in here. It's very important that you need to know, because I'm going to be making a vote for you in Precinct 3, okay? I'm going to be making a vote for you to take your tax money and settle with your tax money, okay? My tax money too. I pay the taxes. And you need to know that I'm getting ready to settle for however 600, 700, 800, 900,000, $1 million. You need to know that if I settle, that I'm going to be using your tax money to settle with. But before I do that, you need to know what's in this host agreement. And this is what my sole premise is. Okay? The landfill, folks, I'm not a betting man. That's why I never win a lottery. Okay? I'm not a betting man. I bet one time that my dad wouldn't go whoop my tail, and guess what? I lost that one too. Okay? I got the worst whooping, but they call them beatings back then. Okay? And so I'm not a betting man. But I do know this. Just as the judge have, Commissioner Beckendorff, and our other colleagues, they may have or may not, I don't know. But I have done my homework on this too. This is one thing I have found out. TCEQ has not ever turned down a landfill permit. Okay? I would assume that the type of business people that Pintail are, that they are moving forward with whatever they're going to do on securing the landfill. I wish the gentleman with blue bonnet, Zach, I wish Zach was here tonight to explain to you some of the differences between the aquifer and recharge zone and all that. Okay? But he isn't. I talked to officials with the Texas Water Board. They don't even want to talk about this. And they're trying to get a water plan for 2050. They're concerned if we're going to have enough water in this state for all of us by 2050. They don't want to talk about this. So, as I read this host agreement, I saw many things in here. Let me put on my good eyes so I make sure that these right here are just some of the money numbers that are in this host agreement that you should know about, so that you can tell me if you want me to vote this thing up or you want me to vote this thing down. I work for you, as the judge said, we all do. And this is over a 30-year period, okay? High school scholarships, $240,000. Library support, $60,000. Grant writer, $500,000. $250,000 for a fire department. Regardless of where the fire department is, it's $250,000. It can be on Mars, but this is what they're giving, $250,000. Revenue to the city, $12,751,438. Revenue to the county, $38,439,315. Now, these are the numbers that are in this host agreement. Some things they have not put a dollar value on, such as scholarships to particularly Prairie View A&M University, things as far as going out and public education, things like that. They have not put a dollar amount on. They are going to educate the public, I guess, on through field trips on how landfills work. But